Hello, aloha. So let me share my screen. Make sure everybody can see. Everybody good? Okay, great. Let me just adjust my, so I can see everybody as well. Welcome everybody. Thanks for joining us this morning. So my goal here is to give you the basics, right? Talk about why it's a good thing to do an estate plan, and recognizing that there are some individually unique things that go on with respect to Hawaii in particular. Some of which I'll talk about, some of which I think may actually require us to do another session maybe next year. And thank you to Kelley for her compelling story. And there's things about that story that are absolutely unique, obviously, to Hawaii and land. But if you think about it, it also is a compelling story with respect to maybe other things that people, that individuals own, that family heirlooms, any number of things, right, that you need to think about because without putting something down in writing and having stated wishes, right, we are left with some default rules. So what I want to talk about today is why you need to sit down and think about these things. I understand it requires going to an attorney. I'll talk a little bit about that. But estate planning is really broader than just your assets, right? Whether that be land, real property, as we call it, or even personal property, right? Family heirlooms, any number of other things that you might own that are in your house, for instance, that you would want to make sure gets passed down to the next generation. So estate planning involves having a will, potentially a trust, as we'll talk about, but it also encompasses what I call two living documents, right? And it deals with your potential incapacity at some point, right? Whether it be just living nice old age, right, and having some dementia or other memory issues, or more tragically, something that happens to you when you're younger that may prevent you from being able to make decisions with respect to your property or with respect to yourself, right? And that's the power of attorney for finances and an advanced healthcare directive as well. And probate will be the process by which assets that are in your name only will then require your descendants, right, those who survive you, to have to get the courts involved. I'm going to explain all that as we go along. Okay, so why do people not do an estate plan? Excuse me. Don't have enough money or property, or at least that's the perception, right? Avoidance or fear of your own mortality. For some people, this is a significantly difficult topic to talk about. So when I teach this class to law students, they often are amazed at how easily, I'll talk about things, we'll get into fairly difficult topics. And I say to them, I'm not being glib in a way where I enjoy talking about death and all those things. But as attorneys, we really do need to be the ones that help people, right, discuss these. It's all the what ifs that we are there to help guide you through the process. And that's what distinguishes, I think, a good attorney from you downloading a form off the internet, for instance, right? It's thinking about all the what ifs. Maybe you're just a person who's disorganized about your personal affairs, right? Cost or fear of process, fear of an attorney. Sometimes we seem like these omnipresent beings, and we actually are not, of course, but not wanting to feel, and the money aspects of it, obviously. Indecision about details, just not sure what you want to do. And then finally, and perhaps most damaging, incorrect assumptions about the law, right? And I think even Kelley's story shows maybe not conscious incorrect assumptions, but certainly maybe trusting that somehow these things are already taken care of by the law, and they're not, right? So, and I think especially if you own land, right, on these islands, which is such a rare resource. It's not the same issues that I dealt with when I lived in the middle of the country where land is plentiful and you know, relatively indistinguishable, right? Especially when I lived in Nebraska, where you know the land is flat and goes on for eternity. Very different here, and so it's a precious resource. It's a precious possession, obviously, that I've been able to enjoy a little bit as an outsider. That really needs, that deserves, right? I think the attention. So what I want to do is really, first of all, give you a few short illustrations, right? No better way to explain something than to give an example. And these examples will be, okay, what are some traditional family setups or non-traditional? And if you don't do a will, what happens, right? So if you don't have either will and or a trust in place, some writing that expresses your wishes, what happens? Okay. That, of course, will lead to the benefits of a will. And then I'll talk about alternatives to wills in which trusts are one of them, right? And it's not only just an alternative, but it also can be complementary in modern day practice. Guardianship of children, I'd at least just want to mention that briefly. You often get questions from people that say, you know, I'm young, you know, I'm married, I have children, we don't have any money, we don't really need to do an estate plan. Well, guardianship is an issue that you cannot, I think, walk away from, right? And maybe even more important than your assets, you want to have a say in who is going to raise your children, okay? So guardianship, at least expressing that in some way, shape, or form is important. And then healthcare and incapacity planning, which, you know, I am probably certain that most of you have dealt with this in some way, shape, or form, again, with some elderly member of your family, right? Or maybe not elderly, right? More tragically. So in those instances, understanding, again, that you want to give whoever it is that survives you the ability to help you in your last days of life, and then, of course, carry out your wishes after your death. So really, estate planning has so little to do with the person doing it. It has everything to do with who it is you're leaving behind. It's a responsibility, right? It is that, Kuleana, to those who are coming after you. So it's a really selfless act, right? I have a dad that survives. My mother passed away about 5 years ago. So there's nothing more instructive about the law than having to do the practicalities yourself. So even as an attorney, there were so many things that I did not understand from a practical level, right? My dad recently called me and said that he had decided to go ahead and prepay for his funeral and make sure all that was taken care of. And he joked about, you know, this was not the most exciting day of my life, right? But I said to him, thank you, right? Because in the midst of grief, it's really nice when someone has really set forth their wishes. So it's any number of these things that come into play when we're talking about estate planning, okay? So I want to do a little terminology. I'm not going to overly use terminology here, right? But I do want, throughout some of the slides, use a capital D. That's for decedent, and decedent is the person who's died, okay? We do have a word for someone who does the estate planning, right? Obviously, you have to do it while you're alive. We call them testators, but I want to keep this fairly simple today. And what is often confused is decedent and descendant. And descendant is, of course, a person born in your direct biological line. And I'll say not just biological, I should have added to that, also adoptive, right? So if you've adopted, you have the same status. So those are your children and grandchildren. We call them direct lineal descendants, right? And that doesn't include daughter-in-laws and son-in-laws, okay? It just includes those that are related to you either by blood or by legality, right, through an adoption. It does get expanded to include what we call collateral relatives, things like your siblings, nieces and nephews, and their lineal descendants. So we'll talk a little bit about that. An ancestor is obviously your parent and grandparent going in the opposite direction of descendants. And then heir. We often use the word heir. Heir technically means a person entitled to inherit part of your property, part or all of your property, by what we call intestate succession, which is a fancy word of saying the state laws that govern when you die without a will. And there's a saying that says, no one's an heir until someone's died, right? So I can say I'm an heir of my father, although he has a will, right? But I can say I'm an heir, but I'm actually not an heir until the moment of his death, and I've survived, right? No telling that I'm absolutely going to be an heir. So we look to literally, again, not to be glib, who is standing after someone's died if we have to determine where their property goes because they've not left a will, okay? And a will is, I think everyone has an idea of what that is, but it's a document in which you specify how you want your property managed and distributed after your death, okay? And the will, of course, can accompany and directly refer to a trust as well. And we'll talk about that a little bit later, okay? So that's terminology. And feel free to ask questions in chat, and then one of my lovely hosts will let me kind of flag me down, because if someone's really confused about something, I don't want them to wait to the end. Okay, so let's do a couple examples. Traditional family, that's a married couple. So understanding that married couples can be husband, wife, 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 husband, husband. I want to make that clear, right? But they've got to be married. So they've gone through the process. They have a state, right? A state certificate. And let's say 2 kids. The law provides these default rules, okay? And the default rules are triggered when you don't have a will, or you do have a will, but maybe part of the will isn't valid for any number of reasons, okay? And we could get into quite a discussion of that, but we could look at the will is contested in court and part of the will is invalidated, right? In those instances, intestacy can also come into play, or the rules can come into play to determine where that property goes. But let's go with the will's all good. I mean, there is no will, excuse me. Then title controls the property, okay? And the first taker is always the surviving spouse, okay, if there's one. So in Hawaii, if you have a surviving spouse and all of your children, right, you being the decedent, and all of your children are with that surviving spouse, then surviving spouse takes it all, okay? If you have children from other relationships and some children with the surviving spouse, then surviving spouse doesn't take it all. Surviving spouse gets a lesser share, and then the children each get a share, okay? And that also the parents may also get a partial share as well, parents of the decedent, okay? And there is nothing in the law that will govern who is going to be the guardian of any minor children, okay? And let me specify, even if you do have a will, right, the guardianship is an expressed wish. It still will require a hearing before the family court or whatever court has jurisdiction over family law matters, okay? But without a will, right, notice again, no in-laws, no stepchildren for the most part, no friends, right? So if you have wishes that are not those norms that are set forth in the law, you need to do a will. And I ask the question, is this decedent's presumed intent? And often it may be, right? It may be that the person that's died wants everything to go to their spouse and children, and the default rules will accomplish that, okay? But in a lot of instances, there may be other wishes, or they want certain, maybe specific pieces of property, right? Not necessarily land, but other property that they want to leave to a good friend or a niece or nephew, right? Who's not going to be in that running. So an estate plan can provide for guardianship of the children, and it can, set forth wishes that give alternative plans as to how you want to dispose of the property. Non-traditional family, for lack of a better word, I refer to this often in my classes as non-married cohabitating partners, but non-married cohabitants also covers this. And here's the thing, right? The law does provide a lot of default rules in this area, as well as other areas of law, on marital status. Now, we could debate whether that should be the case, but that is the case, right? And the law is really not equipped at this point. There are some, I think there are some discussions and movements afoot to start looking at, you know, validation of relationships other than married relationships. But right now, the law does not, okay? And the law regarding probate or estates is the law that is probably the latest to get updated, right? It's not extremely exciting. It's not as pressing as criminal. So you find that these things will sit on the books for decades upon decades, potentially right before it's updated. So once again, title controls ownership of the property. And I probably need to explain that a little bit more, right? So if you're not married and you choose to not be married, which is of course totally fine, then you need to think about jointly titling property, right? Jointly titling with right of survivorship, as we call it. It's a joint tenancy. So own the land together with a designation that the survivor gets all of it. That's all by title. And as Kelley explained, you got to make sure that that deed, right, that would confer that has to be recorded. Okay, none of this matters unless it's on file, right, with the government. That means if you are unmarried and haven't taken advantage of joint titling, then again, intestate succession law, those default rules will kick in. And the first of those two partners to die, their property will go to the children, if there is any. If not the children, then to parents. If there are no parents, then to siblings and their descendants. So siblings, nieces, nephews, etc. Okay, that's the default rules. That may very well not be the intent of the decedent, right? They've been with someone in a relationship for a very long time. Typically, what they want is for that survivor to get the property. But the law does not recognize that relationship in the default rules. Just the reality, okay? So in those instances, doing an estate plan, along with, and I'm not saying that jointly titling isn't something you should also do, right? But an estate plan is key here to make sure that all or part of your estate goes to your surviving partner, okay, whoever that might be. And remember, we're talking about all the, what we call personal property that you might own, automobiles, okay? I've ridden a lot on mules in Kauai. Chris can have a good laugh on that. And then, you know, things that are in the house, heirlooms, any number of things, all of that, right? You might have specific wishes as to where that goes. You also need to address hospital visitation and healthcare decision-making. That's big. Without that in place, right, legally, you have no right to visitation and or participation in decision-making on their healthcare. So that would be important to execute a healthcare directive, as we'll discuss in a little bit, right? And I realize that maybe maybe in Hawaii, maybe in smaller communities, the doctors will know the patients, know the partners, and that may not be a problem, right? Just by custom alone. But that may not be the case if you transfer to one of the bigger hospitals in Honolulu, right? Or God forbid, you're on the mainland, same thing, right? So yes, there can be people who will disregard this, but you want to have those documents in place so that there's no question as to, I want my surviving partner, right? Or my partner while I'm still alive to make my healthcare decisions when I am unable to do so myself. And blended families. Blended families always are a challenge, right? And when we mean blended families, it's usually, right, there's some sort of divorce. Yes, it could be two unmarried relationships, but either way, we're looking at multiple players on the scene, right? Not just one spouse or former spouse, but perhaps a former spouse and a new spouse. So that's the example here. Husband, wife one. Wife one is divorced from husband, wife two, but you have kids with the first spouse. Not uncommon, right? Again, default rules. If there's no will or no trust in place, title controls. So however again, if husband dies, right? Well, how did he title his car? How is the house titled with wife two, right? That all determines where it goes. The surviving spouse here, wife two, will have statutory rights or rights under the law to get a certain percentage of husband's estate, even if he has no will, okay? And that's a bigger discussion for us, but it's called the elective share. And at least in Hawaii, if they've been married 15 years or more, that entitles the survivor to 50% of everything. Hawaii is actually pretty up to date on its probate code, and the most recent version recognizes marriage as a partnership, right? And therefore, after a certain period of time, the survivor, it's equal, right? It's 50-50. If it's less than 50 years, the statute actually gives a bit less to the survivor, okay? So the surviving spouse is entitled to something no matter what, okay? Biological children will get a share because surviving spouse won't get everything, right? Because the rules won't allow her to get everything because the children of the decedent are not hers, okay? Now, again, if wife one, let's say, died while she was fairly young, wife two comes into play, wife two adopts the children, then they are, right, wife two's children. But when I say that they're not her children, I mean there's been no adoption, right, and no biological link, okay? Stepchildren will receive nothing under the default rules, right? And so if wife two has kids, a kid or kids, and they're in the household and they become, close with husband / stepdad, and, for whatever reason, he didn't adopt him because biological dad is still on the scene. You can't just adopt someone because you want to, right? It's only when one of the biological parents' rights to their children have been terminated by the court, right? So if the dad of the stepchildren is still on the scene, husband doesn't have the ability to adopt them, but he may look at them as like he does his own children and want to leave them certain assets. Again, without a will, the law is not going to do that for him, okay? So again, what is the decedent's presumed intent? What does he want in this situation? And if he wants something different, which probably he does, then he needs to execute a plan, right? A will or trust, some combination, okay? So you can see, I hope that these illustrations are helpful in saying, okay, this is what happens if you do nothing, right? And if you have a traditional relationship, like I said, and that's really what you want, then you can at least rest assured, right, that that's the way the law will provide for you as a survivor, right, or your spouse as the survivor and your children, okay? But that still is not going to address some of the issues with respect to health and with respect to management of property while you're incapacitated but still alive, okay? So we'll get to that in a minute. So what does a will do? Well, a will apply to property that's titled only in the decedent's name at death. So again, right, if Dominique and her husband own a house together and it's jointly titled in both their names, and one of them passes, the survivor by title will automatically get that property. The will not deal with that property, okay? But if her husband has property in his name only and he passes first, and she needs to sell that property or transfer that property, she's going to have to go through probate, which is the process by which you go to the court and the court gives you the power, right? Whoever it might be, usually it's the spouse, but it's the executor, to retitle that property so that the property can be transferred, okay? So again, pre-planning, making sure all property is jointly titled so that your survivor automatically has the ability at your death to transfer that property is key. The will clearly establishes the decedent's intent. Courts are loath, right? Loath to change the language of wills. So provided the will is somewhat comprehensible, even if you handwrite it yourself, and I am not in any way encouraging you to do that, but Hawaii does recognize what we call holographic wills, which are completely in the testator's or the now deceased person's, handwriting. So at the very least, if you're a little bit freaked out by some of what I'm telling you, and I don't want you to be, obviously, you could go home and literally kind of list your wishes, and that will likely be valid until you get something done more formally, right? So Hawaii is one of the states that recognizes it. Not every state does, though, right? But if you plan to live and die here, know that that's an option. Guardianship for children. Okay, again, so I've got another slide on guardianship, so let me talk about that in a minute. Disposition of your personal remains. So now we're talking about, this is what I want done with my body when I die, right? Whatever the case may be, you could set that forth in the will. Actually, Hawaii also allows a handwritten document that says, these are my wishes. Okay, so just another thing to let the survivors know what it is you want done. Do you want burial? Do you want cremation? What is the options, okay? And then Hawaii also, like a lot of states at this point, allow you to do what's called a tangible personal property list that accompanies your will. So your will say, I leave all, certain tangible personal property in accordance with a list, right? You refer to the list. That allows you to sit down even after you've executed your will, right? Which is the formal process of signing and having it witnessed. You could sit down and put together a personal property list. My grandmother's brooch, any number of certain, your rings, your jewelry, right? Specific items that you want to go to specific individuals. And again, if that's done either in your handwriting or you type it up and you sign it in your handwriting, that list will be valid. It's to supplement what, like my grandmother did, where she literally put a little note under specific, right, heirlooms, china, things of that nature, saying this is where I want to go to. The law now recognizes an easier way. So your will doesn't have to have 30 pages of my diamond ring from, grandma so-and-so and all of that. You can put that down on a list. Now, if it's a really valuable piece of property, right, you may not want to leave it to that list. You may want to make sure it's specifically in the will, right? So if it's worth a lot of money, I would say don't use that list for that piece of property, right? But for the most part, again, that was something that I encouraged my mother to do, and it was extremely helpful, right, when she died, to have that list and know where she wanted certain pieces of jewelry and other things. I have a lot of sisters, so it was easy to know where she wanted things to go, right? And then we had to figure out what to do with the things she didn't list. A will is not the only way to plan for distribution of your property at death, right? I keep mentioning this, but titling of your property is key, especially your land, your house, right? But also it could be automobiles, right? Boats, anything else that requires some sort of titling. Think about that, right? Spouses often may not think, oh, well, if he goes out and buys a new truck or whatever the case may be, try to make sure that you put either your spouse or your cohabitating partner, right? Person you're not married to, on that title so that it's easily in their hands at death, right? And you should do that even if you have a will. It just makes it easier. Beneficiary designations. These are also things that a will does not address. We're talking about the beneficiary of your life insurance, your retirement accounts, right? If you work for the state, your pension, whatever the case may be, you list those individuals, right? Or potentially a trust, as I'll talk about in a minute, as the beneficiary. So again, at death, that property is already designated to someone. The will does not do it. In fact, the life insurance industry has been pretty stingy in having the law get involved in their business, meaning the way to make sure life insurance proceeds are designated as you want, you need to fill out their forms and follow their rules. Life insurance is looked at as a contract, right? So actually the will doesn't, right? In Hawaii, in the vast majority of states, the only way you can change a beneficiary in your life insurance is to do it as the company sets forth, right? File that form, have it notarized, whatever they require. A will is not going to be able to do that for you. Don't forget that you can title your bank accounts and your investment accounts, right? Jointly title that with your spouse, or again, with your non-married partner, if that's who you choose. Titling those means, again, at your death, they are already in that other person's name. Don't need a will to do that, okay? We'll talk about a trust in a minute as an option. It's a fancy name, but it's really not meant to be fancy. A revocable inter vivos trust simply means a trust that you form or create while you're alive. Inter vivos means alive or living, okay? And you hold the power to revoke. So just like your will, you can change it as many times as you like, provided you have capacity, right? You understand what you're doing, right? You're not in a severe dementia state of mind. You can do that throughout your life. And then Hawaii does provide for a small estate probate procedure to keep it really simple if someone dies without a will, but it will not be a procedure you can use if you own any land or real property, right? Your house. Okay. So these are all ways. And then with all of these, I'm going to be clear on, especially beneficiary designations, right? And some investment accounts. The company is going to require the death certificate. So I'm going to be glib here, but the death certificate is your ticket to ride if you're helping to administer an estate. So get at least 10 original copies, because, you know, life insurance companies, those who administer retirement accounts are going to want an original death certificate of the deceased in order to disperse those funds. Okay. And who knew, right, that the death certificate was such an important document. Sometimes they return it, but often they keep it. And if you think about it, you can hardly blame a company if they're distributing a large amount of insurance money to want to make sure that the deceased is actually dead, right? Again, I know that sounds fairly glib and fairly, you know, direct, but this is the way it works, right? So these are all important planning techniques. And so you're like, well, then if I can do all that, why do a will? Well, fair enough. If you do all of this, right, and the attorney shows you how to do this, the will can be fairly small and fairly simple, and the will is there to kind of collect any property that all of this other work doesn't designate. So will say, okay, all the contents of my house, right, can go to all my children, and they can figure out how to distribute it, right? No one's going to ask for a title to your couch, right? Or appliances in your house. Those kinds of things are, you know, if you, a will at least help capture anything that you didn't retitle or designate somehow. And then you can kind of do what we call a residue or a remainder clause, which just says, hey, all my other property that I haven't listed or haven't dealt with, this is what I want done. Distribute to my children in equal shares, or first to my spouse, my surviving spouse, right? And a lot of times those things become much more important on the second spouse or second partner to die. So probate for my mother's estate, for instance, was pretty straightforward. Almost everything was jointly titled. I think she only had one bank account in her own name. She had already designated that for the grandchildren. And everything else my dad automatically owned at her death. And really, it's my dad's estate now that will, you know, determine whatever's left, right? So a lot of times the estate planning is going to kick in a bit more on the second spouse's death or the second partner's death, more so than the first. Or unfortunately, if they die simultaneously. So let me bring that up really quickly. Yet another reason to do a will, right, is what if you do have children that are minors and you both die in a car wreck, in a boat wreck, whatever the case may be, drowning, right? In those instances, it's really important to have at least something in writing for guardianship and other types, how you're going to provide for your children's financial means, etc. Right? Again, this gets a little depressing when I teach it in class. I actually have some students who will, stay after and say, God, this is really bumming me out. And I'm like, fair enough, right? But if you have children, they become your top priority, as you all know, and you want to make sure you take care of them. So even if you have the smallest amount of assets, a simple will dealing with the guardianship of your children as persons, and there's actually two things here. Let me go to that slide. I'm going to skip over to guardianship. It's guardianship of your children as persons while they're minors, and guardianship of property that you want to have in place for the support of your children, okay? So you can designate that in your will, or you can designate it in a trust if you want to do a trust because of land and other things. Or you can also, in most instances, have some sort of writing, some written document that states your choice of guardians. Again, the law has not caught up to technology, so you can't assume that if, I keep using Dominique, if she writes all this out in a document and it's saved to her hard drive on her laptop, that's great, but the law isn't quite that advanced yet, so it would still be better for her to print that out and sign it, right? Her actual signature, right? And throw that in a safe deposit box or a safe of some sort. Electronic files, electronic wills are not yet recognized. And Hawaii, right, does not have a lot of law regarding this area. So that's all in process. It is something that, certain commissions that look to laws are drafting now, but we're not there yet, okay? Just remember that the guardianship designation is just a designation. It doesn't mean that if Dominique says, I want so-and-so to raise my kids, that automatically happens. I mean, they can take possession of the kids, obviously, temporarily, right? If there's been an accident where she and her husband both pass. The persons she is designated will at some point have to go to family court, right? To get actual guardianship conferred. It's got to be by court order, okay? But her designation will be given a lot of weight, okay? So absent the people being, having real capacity issues themselves, if they present themselves as not being, really together in the court, that might be, but for the most part, her designation will be followed by the court, but the persons she's designated need to get that court order of guardianship. That allows them then to make decisions about education, decisions about healthcare, and those types of institutions will likely at some point want to see the actual guardianship order. Okay. Just want to take a slight break. Any questions thus far? It's a lot of info, right? So remember, I teach this. Sorry, go ahead.
There were a few actually, if you want.
Okay, good.
I love the mid-question session. So the first one was, if someone passes without a will, who do you contact to find out who the court appointed as probate?
Good question. So someone is going to have to petition the probate court, whatever court has jurisdiction, to have what they call, to have the executor appointed. They technically call the executor, when you're looking at a person without a will, they call them an administrator. Doesn't matter for the most part, right? Executor just means that I've picked someone to be the person who administers my estate. But the point, so they will look to, so typically they'll look to the surviving spouse first, then children. So there's kind of an order of designation, but you'll have to petition the court. Someone who has an interest, which is usually a family member, maybe even a joint owner of property. Good question.
What if it's something like it was a great uncle or something and it's passed and done, but you don't actually, and you're researching your genealogy or is your great-great-grandfather,
yeah,
you see, hey, was it left alloidial to all the descendants or was it left to the second evil stepmother, like you said, or something like that, How would you search that probate?
So for instance, there's a friend of mine who lives in Kauai. You guys might know who I'm talking about, who had an auntie that passed away in the mainland. And at first they weren't able to find a will. And so they did have to petition the court. to at least appoint an administrator in the short term so that they could start. And then there's a way in which this gets fairly complicated where they do an heir search. So if it's not clear who their immediate family is, or maybe they didn't have any children, right? Then the process gets much more complicated. Probably an attorney is going to need to get involved at that point, and there are ways to search for heirs to ultimately determine, right? Not just who should administer the estate, but who is actually eligible to receive under the estate. Did I answer the question?
I think so. Where would that be filed then? Like if I was like a cousin to said person, I think I know you're talking about, like, and I wanted to find out what was the result of that, and it was like 20 years later, where would I search that?
So there'd be nothing, if they don't have a will, there's nothing on file, right? And wills are not filed with court until they die, until the person dies, right? But if it's a determination, if you can't find a will in their personal belongings, then you're going to have to go to court and have the court appoint someone, at least temporarily, to administer the estate. And they'll look to see who's around. And if it's not clear that there's someone around, meaning, you know, a child, grandchild, even niece, nephew, if we can't find a close family member, that's when that heir search would have to happen. But that's why I said you're not an heir until the person actually dies. We got to see who survived. So, in that instance, this auntie, both of her children had predeceased her, right? And then eventually a handwritten trust was found. Handwritten will was found, and it was executed in Hawaii, which allows those wills to be valid. So that was a great, great find. But that's the other thing. If you're going to put stuff in writing, whether it be a will and or something else, let someone know where it is, right? It could be with the attorney who helps draft it. If you do it on your own, right? Make sure there's a safe or safe deposit box and that someone has access to it so they know where to go first.
I think there's one more question that's on this topic. Sure. I have 3 questions, including the one that just popped in the chat. I'm going to hold to the end because they're not as related immediately, but we'll definitely get to that. The other one about what you just talked about was you had, in your last one of your slides, you had small estate probate procedure. This question was emailed in. It said, that was a procedure you said after a death that would be kind of quickly processed with no land. In the case of Hawaii, where you have a lot of these ʻOhana heir lands that are passed down on loidio from Hawaiian Kingdom times, what if you don't know you have a land interest?
That's a good question. And I guess that's an instance where, and I know that's unique to here too, right? Where you're going to have to, whoever the administrator of the estate is going to have to do some searching. And I know that's not easy. And so I would refer them to you, Dominique, and say, hey, there's someone who researches this kind of stuff. This is where things can get lost, literally, right? Property can be literally lost. And I know your speaker from last week talked about, adverse possession issues, right? So this is why putting things in writing is so, so important, right? And making sure if you're elderly that you have put this history down somewhere so people know. So I don't have a great answer except to say, is it possible that if you don't know that they had land that somehow it will be missed? Absolutely. It's an absolute possibility. So, you do title searches in the Bureau of Land or Bureau of Conveyances. I think it's called Bureau of Land. You do title searches. You get, right? You have to do those you're gonna have to manually get, and the attorney can help you with that stuff too, right? Do searches to see if anything has been, any deeds have been registered or filed, et cetera.
Okay, awesome. And then I'm going to hold the other two questions to the end because I think they're very relevant, but not specific to this. One question, is a probate settlement recorded at the Bureau of Conveyance?
I don't think the settlement itself is, but if the probate settlement directs that, gives, of course, someone the property, then I think they'll need that probably to retitle the property. So I guess it could be recorded along with the deed. I guess that's a possibility. I actually don't know the recording procedures as well here in Hawaii, but you obviously would need it to execute the deed to be recorded. But that's a great question, because you want to follow through on those, right? Not just take possession of the land, but make sure that that title gets re-recorded in the proper owner's name.
And I have two questions we'll hold, but I'll let you keep going.
Okay.
And just keep throwing questions in the chat. If they're immediate, we'll ask them as our next breaks, and if not, we'll save them to the end.
And we're close to the end, so that's good. So I want to briefly discuss trust. Okay, and I wasn't sure if everyone really understood what a trust was. And unlike a corporation, forming a partnership or an LLC of some sort, where there is a filing with the state, right? The Department of Commerce and Consumer Affairs here, Secretary of State in most states, a trust is not publicly filed, right? And just like a will, a lot of times it does not become public until there's a probate or some sort of court action involving the document. The trust is what we call in the law a fiduciary relationship, right? That's what we call it. Now it's in writing, so we call that the trust instrument. But the trust is really a means by which I can take property that I own and I can designate that someone have legal title to that, right? Be able to manage and preserve the property, that's the trustee, for the benefit of someone else. And that's your beneficiaries, right? So the relationship is, this allows you to kind of bifurcate or split interest in property, because you want to deal with minor issues. Minor persons who are still minors, who can't take the property legally in their own name. I have a slide coming up that kind of says where this can be useful. The trust allows, of course, then for at least an extended period of time. I know that Lance talked about the rule against perpetuities in the discussion last week, but it does allow for property that you're not going to maybe immediately distribute, right? To be managed, preserved, right? For the benefit of either stated or future beneficiaries, right? So it could be, you could say for your grandchildren, and your grandchildren are not yet closed yet, meaning there's still more to come. The trust is a great vehicle to make sure that your wishes are carried out. A trust can be formed in your will at your death, or I think more effectively during life, right? And you execute an actual trust agreement, and you set forth any number of provisions on how you want the trustee to act, right? Talk about who the trustee is, who the successor trustees should be, and then who your beneficiaries are. So we call the creator of the trust the grantor or the settlor of the trust. Just like a will, they're the person that are creating the plan, so to speak, okay? And they transfer property to the trust. So it would involve, with real property, literally retitling the property in the trust, and we'll talk about that in a minute. The trustee is the person or entity, so you could have maybe the trust department of the bank, it could be a trust company that helps manage the property, but a lot of times it's a family member. They, when I say they have legal title to the property, if I have Dominique be my trustee, it's not that she owns the property as Dominique. She has legal title to the property as Dominique, trustee of the Nicholas A. Mirkay, right, trust dated, blah, blah, blah. So her legal rights are only in her role as a trustee. And of course, if she tries to do something with the property for personal benefit, that would be a big no-no. And then we have both fiduciary duties, right, of care and loyalty, that the beneficiaries could literally bring her to court, okay? And the beneficiaries really don't have a lot of power on the trust, at least while it's still in the trust, meaning I can grant someone, they have beneficial use or possession, whatever it is I say that they have. They might have a life estate where I say you can enjoy this house on Hanalei Bay until your death. And then at your death, the trust can distribute the property to the grandchildren to own in equal shares, right? Which I know then could bring up partition issues, right? That I know you guys have talked about. But the trust gives a lot of flexibility, right? That you can't have if I just gave the property to Dominique outright and she owned it. If I said, listen, I'm giving this property, so in my will, if I say I leave my, my real property in Honolulu Bay, date, described, address, all of that stuff. And I say, and it is my hope that she will allow my family to also come and stay in the property. That hope is not a legally binding, right, condition. It's a moral obligation, but it's not legally binding. So if I don't want to give someone property outright, but I want it to be open for use and, in many different ways for different periods of time, the trust allows a lot of flexibility, right? So let me move on to the next slide. So by using a trust, a settlor or creator, right, whoever creates the trust, can ensure property is managed and distributed pursuant to their wishes. They can postpone decisions on investment and distribution. So it's not just land, you could put stocks and bonds and other assets in there. And you can give the trustee some discretion, and the trustee can hire an investment advisor. Now I'm talking about people who really have a lot of assets and are rich, right? A trust can really be quite effective in managing the property. Trusts are really extremely important if you have incompetent persons. So if you have your own property in trust and then you become incompetent but still alive, you can tell your trustee how you want that property managed for your benefit until you die. You can give discretionary. Discretionary trust is just a fancy word for saying, I am going to give the trustee discretion and maybe less boundaries because I trust them, pun intended, right? And you give them a lot of discretion to determine what's best, right? Maybe it's rental property, and at some point, because of erosion, I don't know, too many tidal waves, whatever the case may be, you give them the option to sell the property if they feel like it's best to preserve then the proceeds, right, for whomever you want to benefit from that. Trust for minors is obviously a big issue, right? So having a trust in place, either because you execute it during your life, or even if you do it in your will at death, right? You can have a trust that's formed to hold assets for the benefit of all of your minor children until they reach a certain age. And it doesn't have to be the age of 18, right? Increasingly, people are saying, okay, I don't want the children to have assets till they're 25 or 30, right? They're just not mature enough. Maybe they're Paris Hilton and they spend the money too quickly. So I'm going to leave that property in trust and appoint a trustee to only allow them a certain percentage of the money until they reach certain ages, right? So all that flexibility is inherent in putting property into a trust. So if you have any minors, right, it's important to have a trust set up. And it can be pretty simple language in a will, right? But a trust that's set up for them until a certain age, where then you want the property distributed to them outright, and then the trust dissolves. When I list testamentary marital trust, that's another fancy legal term, but that would be for people who are coming up on potentially owing estate tax. And there are ways to structure that so the tax is not owed until the second of the spouse dies. And so that's a much more complicated topic, but trusts are used there to at least escape tax after the first of the spouses dies and delay some of that tax to later. So that's kind of the basics of what trusts can do. And then I just want to, before I move on to this, which is our last topic, with trust, and I know Kelley, I believe, mentioned this, but one of the issues with these issues of forced partition sales and everything, there is a way at least to try to prevent some of that from happening by having a family trust. The complications, of course, are getting the family to all agree on how that property should be used after your death, right? So while trusts are a really, so if if I own the property on my own at death, it's my party, right? I can say I only want this property used for certain purposes, and that's it. Or I want my children and grandchildren to enjoy the property, and then upon the last grandchild to die, I want it to go to the state for preservation, right? So the land can be used for, to preserve non-commercial use, any number of ways that the trust can be useful. So the discussion of trust is almost boundless, right, in what can happen, and it can, in some ways ensure that the property is used a certain way, and not sold off, so that another resort can be built. Okay. I want to talk just briefly about healthcare and incapacity. A durable power of attorney is a document that you would create, or execute, right? So that if you are alive but incapacitated, someone can manage your finances. So you literally can take this document. If you're the appointed, what we call agent or attorney in fact, and go to the bank, right? Get your name put on the account so you can pay their bills. So it's always with respect to finances, okay? Durable means that the power of attorney lasts while I, maybe the person who executed it, while I am alive, but do not have the capacity to give directions, right, as to what I want done. So the durable power of attorney is really important when someone is incapacitated but still alive. Healthcare directive is really the same thing, but with respect to healthcare decisions. Sometimes you do see it called durable power of attorney for healthcare, right? It is recommended though that those two documents be separate, right? The bank doesn't need to know what your healthcare wishes are, so separating those two documents out. And the healthcare directive at least has a statutory form, or one that was in the law. I give you some links. There's also a handout that I provided to the host that give you some links to that document. You can execute it without an attorney, but it really is you thinking about, I'm alive, but I'm incapacitated, right? Either because of an accident or because of a terminal illness. And here's what I want to happen in certain circumstances, right? If I'm brain dead, I want nutrition withheld, but I want, hydration so that I can die peacefully. You get into those kinds of specifics. Whoever it is that you direct to help to make your decisions for you, right? You give them direction. It's not like they can just do that on their own or pull the plug, so to speak, on their own. It is in consultation with the healthcare provider. Again, I'm getting really just a broad overview, but those are important documents to have. Hawaii also allows what's called a POLST document, which is a provider order for life-sustaining treatment. Now I'm getting really pretty morbid here, but if you have a terminal illness and you want it to be very clear, you do not want to be resuscitated, right? If something should happen. If the emergency personnel come to your house, right, they are not going to take the time to read your healthcare directive, nor should they, right? If you don't have something there, they're going to preserve your life. That is their responsibility. A POLST allows, and it's typically, and you can see the link, it's a bright green piece of paper. It should be on a refrigerator or something, or somewhere where someone can find it. And it's very clear, and you execute it with a doctor or a licensed nurse. And it sets forth, here's what I want to happen in an emergency situation, right? I don't want to be resuscitated, whatever the case may be. And they will follow that, but it's a set document, and it's got to be very easily found and displayed. So another little nugget of information. So that's your summary checklist of everything we've talked about. Think about doing the basic will. Perhaps a trust is necessary or would be helpful to collect all of your property into that trust at death. So not just real property, but it could be your life insurance proceeds, all of your retirement and bank accounts. If they all are designated to go into the trustee has an immediate ability to govern those assets and start using them, right, for the benefit of your children, et cetera. Just talked about the next two documents. retitling of the property, if you do have property in your own name, right? Thinking about that. I'm not saying go out and retitle property and put someone on there unless you're absolutely sure you want them to have it, right? So again, that would be spouses, persons like that, and then retitling beneficiary clauses. Okay. It's a lot to cover in a short amount of time. So what remaining questions do we have?
Well, I think
or are we at time?
No, if everyone doesn't mind staying on a little bit, we have a little bit more time, and we'd love to get to questions as long as everyone's able to. And we will be, I believe, recording, so it'll also be there on file. I think